Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have a spectacular webinar from our fabulous attorney in Ohio, Russell Rorick, on don't sign a lien waiver unless it says this one thing. So without further ado, I introduce the fabulous Russell Rorick.
Thank you, Ariella. How do I follow an opening act like that? I mean, it's always wonderful to hear people say great things about you. So thank you so much. Let's get right into our program here today. I'm sure most of you have been here before, so you know the whole story. If you have a question, put it in the chat box. I do have the chat box open, so if I see something that'll fit right there, I'll answer it. If I don't see it, well, I'll collect them at the end anyway. So on with the show. It happens to everybody. You're not getting paid, you call, you want to find out what the story is, and you hear all kinds of things. One of them, the worst one, is, well, one of the worst ones, is you signed a waiver releasing us. You know what? That happens all the time, whether you know it or not. If you don't read your lien waivers, you're going to find the most awful things in there that have released them from all kinds of claims. So let's start to look at some of those as we go through here, and we'll get to the real meat of the worst one of all. The contract requires you to sign our choice of waiver. You had to pay attention to your contract to begin with, and you do have some negotiating power at the beginning to get your waivers in. So you're not signing awful waivers all the way through. The contract requires you to sign this waiver. Well, that's what we just talked about. If you don't file, if you file a lien and you don't release that lien, you'll never get another job. Well, my take on that is you're never going to get another job unless you're low, in which event you'll get another job. So I tend to not worry about that. Maybe you don't file it against your best customer. Maybe if you do file it against your best customer, you tell them ahead of time because you need to get it done. Sometimes I actually clients call me and say, file a lien, and with their permission, I will talk to the contractor first because I have relationships with some of the contractors. And we'll get all kinds of answers. Sometimes it'll be, we didn't realize it was a problem. We'll have you check out today. And sometimes it's, well, there's a big dispute, so go ahead and file your lien. It all depends. So it all starts at the very beginning. Condition your bid. Negotiate your contract. Consider specifying your lien waiver forms too. You're going to condition your bid on all kinds of things, like trying to get rid of pay if paid clauses. And that one's a tough one. But one of the things is, what we're talking about here today, is getting a good lien waiver. Lien waivers are important. In fact, lien waivers drive the whole payment process, which is why we want them there. There are 4 different types of lien waivers you need to be cognizant of and be sure you're using. A conditional partial lien waiver, an unconditional partial, a conditional final, and an unconditional final. Sounds simple enough. Let's start to talk about what they are. Now, this condition your bid issue really works. There's a Franklin County Court of Appeals case, which is complete general construction versus card welding. And essentially, to keep a very long story short, the concept of making a contract is different when you're bidding, because when you want to sell something to somebody and they say, I'll pay this much for your product, and you say, okie dokie, there's a contract formed right there, and you can withdraw your price at any time right then and there before it's accepted. But when you're bidding, particularly when you're bidding to somebody else who is going to use your bid to bid, then there's an issue of reliance. And if you make a bid to them, they use your bid, you can't then withdraw it, even if they haven't accepted it yet. Card welding says they have to honor your exact bid, or you can withdraw it. So if you say this contract is contingent, this bid is contingent upon you're doing X, Y, and Z, is contingent upon you're paying within 30 days of invoice, is conditioned upon using specific lien waivers, the lien waivers that are attached here too, that type of thing. Then if they don't accept those exact terms, you can walk, or you can negotiate until you get a contract that you feel is fair. So these lien waivers we're talking about, the unconditional ones are the problematic ones. Where are you in the process? Are you finished? Have you delivered everything you're going to deliver? Have you performed all the work you're going to perform? If you have, then you're going to sign a final lien waiver. If you're not, if you're only partway through, then you're going to sign a partial lien waiver. And by the way, the final lien waiver would include everything, including the retainage you're going to get. So even though you're finished, doesn't mean you're going to waive it if they're going to hold retainage for, pay you everything but the retainage, and you're going to get that in some long period of time. Sometimes retainage isn't released until a year later, which is, of course, obscene, but it is what it is. That you should have negotiated out if you can. If you're finished, you're getting your last pay, fine. Sign a final waiver. If you're partway through, you're only getting paid part of what you're due, you're going to sign a partial lien waiver. Now, these unconditional lien waivers, have you been paid? This is what it's going to look like. In consideration of the sum of X dollars, the receipt and sufficiency of which is hereby acknowledged, the undersigned does hereby waive, pretty much everything in the world. Okay, well, that's the first part that's okay. If you've gotten paid and the check is cleared, if you don't trust it necessarily, then you're okay to sign this unconditional waiver. Remember, this isn't an unconditional final necessarily. This may be an unconditional partial. So what if you're still waiting for the check or waiting for the check to clear? You hear all the time, sign this lien waiver and I'll take the lien waiver to the owner and I'll get paid. Or here's the check, and maybe this is a large company and it's not going to bounce. Maybe it's a small company and you'd really like to be sure that it's going to clear. Now, giving you a check that is returned for non-sufficient funds is actually a crime, and it gets bigger. It gets into felony status if it's a large bounce. But still, which do you want? Do you want to send the person to jail? Oh, well, maybe. Or do you really just want to be paid? You just want to be paid. You could care less about their, personal life. Your conditional waiver. This is what you wanted to read. Upon the receipt of the payment, the sum of whatever that amount of money is, and when the check clears the bank on which it's drawn, we're going to waive this, that, and the other thing. Now, the this, that, and the other thing is also an issue. You don't want to waive everything in the world. You want to waive whatever you're being paid for and not a penny more. And additionally, not any claim. You want to be paid. Here's how it goes. You start in month 1. Let's say you start on October 1st, and you work until October 25th or whatever date you have to have your pay app in, and you submit your pay app. 30 days, well, the contractor then submits their pay app, and 30 days later, theoretically, they get paid. And under Ohio's prompt pay law, they have to pay you within 10 days, except they're going to withhold retainage. Y'all know that. So where are we? The check hasn't come in yet. You've given them this conditional waiver so they can go get paid. Now they've given you the check. Now you can give them, if you trust that check, when you get paid, you can give them the unconditional waiver. And somewhere about the same time, you're going to give them another conditional waiver, maybe even in the same transaction. Maybe you go pick up your check, maybe they mail it, whatever you're going to do. You're going to send them a conditional for next month. So you always have this process. The owner can always understand where the conditional waivers are, where the unconditional waivers are, and know that they have limited exposure, that there are payments being made and waivers being given. So in this, let's just talk for a second about any of the waivers, conditional or unconditional. Remember what I said, you invoiced through the 25th. And the invoice will say, the waiver will say, whether it's upon the receipt of the payment or, for, this amount received, which is acknowledged, we waive all payments through the date hereof. Nuh-uh, technical term, technical legal jargon. Nuh-uh, why? Because you haven't been paid through the date hereof. You've been paid through the 25th of last month, not even this month. So you want to waive the right stuff. You also want to waive your right to be paid anymore. You don't want to release all claims. Well, you might have unresolved change orders. That's a claim. You might just have waived that. So be really careful. If you have an issue and you want to know where you stand in it, you've got a crazy lien waiver, one you haven't seen before, or one you're just not sure about, call me. I'm happy to look at it for you, and I'm happy to chat with you for 10, 15 minutes and work through. I'm not going to charge you for it, and work through all this to make sure that you're signing the right lien waiver. So when you're still owed money or you have other unresolved issues, you're only going to give them a partial lien waiver. When you're paid in full, including the retainage, and all issues are resolved, there's no remaining condition. And what I mean by that is there are no unresolved change orders, there's no anything that's pending. Then you're going to sign the paid in full final unconditional lien waiver. That's just fine if everything's okay. So here's what it's going to say. The undersigned certifies, represents, and warrants that the undersigned has been paid in full and hereby waives and releases any right to mechanics liens, stop notice, claim, choses in action. You ever hear about a chose in action? You learn about that the first year in law school and you pretty much never see it again. But choses in action, or any right against labor or material bond on the project. So you've waived lien claims, you've waived bond claims, you've waived stop notices, which are essentially an order for, in Ohio, it's the public authority to stop paying the contractor. It's what it's called. So all those things you're waiving because you have been paid in full on everything. Perfect. You're happy, you're going along the way. There might be claims coming back against you because you're not going to waive those, or they're not going to waive those. And the claims against you will be, a warranty issue or something like that. When they're overbroad, here's some of the things that I was talking about before. Waive and release any and all liens and claims it has upon the foregoing described property through the date of this waiver. If it's the final one, that's okay. If it's a partial one, you have just waived way too much. Now, and this happens. I see this all the time. I had a client that came to me and said, "Oh my God, we deliver their windows and doors." They had $114,000 worth of unpaid invoices over the last year. And this is one of the ones where they said, okay, I have a good relationship with the contractor, not my client, but the type of guy I always trusted. Called him and said, "Chuck, I've got a claim on this project, 114 grand, and they want me to file a lien, so have a look. He said, I'll call you back in 10 minutes. Calls me back in 10 minutes. Says, I have final lien waivers, unconditional lien. He said, I have unconditional lien waivers for every month for the past 12 months. And what it was my guy kept signing these unconditional lien waivers. So he waived all of his rights up until this last one where he finally said, that's enough, I haven't been paid. And what the contractor said to me, Chuck says, I have $17,000 left in this entire account. We're happy to pay it to you because nobody else has made any claim. Everybody else has signed all lien waivers. We're golden here. I can give you the 17 grand. And I talked to my client. The answer was 17 grand is all you're going to get on the lien issue. And you don't even have a lien claim because you've already waived all that. So you need to do it. We took the 17 and then we chased the contractor for the rest. It would have made it so simple had they used the right lien waivers all the way through. That contractor would not have continued to pay the subcontractor, and thus my guy would have either been paid or the contractor would have held enough money to cover what we had. That's the issue. That's how this all works. In Ohio, we have this notice of furnishing thing. And the point of the notice of furnishing is to tell the owner and the contractor, if you're a sub or supplier to a sub, and the contractor that you are supplying labor and or material to the project. That way, every time it comes time to write a check to the contractor, they can look through their list and say, I need to see lien waivers from all of these people who have given me notices because they have lien rights. So that's good. You've staked your claim, you've done the notice. The owner does the right thing and says, I'm not giving you this check, Mr. Contractor, until I see these lien waivers. Okay, now the contractor, the owner, is going to be exposed for 1 month because you're going to give this conditional lien waiver, and then that conditional lien waiver he's going to release the money on. Then he's going to get the unconditional lien waiver for that money just received, along with the conditional lien waiver for the next month. So he's only got exposure for 30 days, 31 days, whatever. That's the way it really needs to work. And that's the way it's worked this entire time through kind of the beginning of mechanics liens. That's the type of overbroad waiver you're never going to sign unless it's your final lien waiver, the one you're looking. Is going to hold the right amount of money, or if they don't hold the right amount of money, at least you have lien rights for it because they were on notice that you weren't being paid.
If you don't mind, there was a little bit of an internet or some type of a disturbance. Can you go back to 2 slides? I'm sorry to make you do that. If you
Oh,
could go
no
back.
problem. Tell me which screen.
That one, right after that one. If
This
you
one?
could, yeah, unfortunately, something happened with the sound. If you
Okay.
could, it says, yeah,
Yeah,
right
no
there.
problem.
Wonderful. Thank you very much.
Sure. Okay, through the date hereof. This is what we talked about before, and this is the most common form you see. The lien waiver is effective through the date hereof. That only works if it's for final payment and you have been paid. Why is that so important? We talked about that before, because your pay application is through last month. You're not getting paid. Your pay app was through the 25th of the month, and now you're getting paid on the 10th of the following month. So essentially, you've given up 30 days for month 2, 5 days for month 1, and 10 days for month 3, the current month. So you've given away way too much when you haven't been paid. Go ahead and change it. Change it right on the form. They'll be upset, but so change it. And you say, well, they want it in an affidavit form. Why? I don't know. But it's usually an affidavit. So you say, I can't lie in an affidavit. Here's the amount of money that I'm still owed for retainage. And it's only effective through the date of my invoice. You're not paying me for all of September and this 10 days in October, are you? No. Okay, so let's do it right, because I want to tell the truth. They'll give you a headache on that unless you have negotiated. They can give you a headache on that unless you've negotiated a good form. Sometimes I just tell clients to go for it and give them, don't return their form to them, return the proper form to them. Does that work? Works 90% of the time. Sometimes you really have a hard time and you've got to fight it, but do what you need to protect your payment. If you don't, it's going to turn around and you're going to find out, not every time, but every once in a while, it's going to be a big deal and it's going to be a lot of money and you're going to be very sorry. Be sure retainage is excluded from your waiver. They almost always say, as I said, through the date hereof, and they don't say except for retainage, despite the fact that they've withheld probably 10% on you. And I say probably 10% because that's really the common thing, even though it's silly. And sometimes if you're a first tier sub or selling to a prime contractor on a public job, it's a state or local job, it's actually illegal. Almost nobody knows that because nobody reads the administrative code, but it says there right in the administrative code that they can't withhold more from you than is being withheld from them, but that's a whole different seminar. So possible relief. One of the things that you can go against is, let's say you're just trying to get paid. You're not worried about the lien. You're worried about being paid. And you say to let's say you're working for a subcontractor and the subcontractor says, oh, you signed this lien waiver, tough cookies. I don't have any real responsibility to you anymore because you signed this lien waiver. Well, not necessarily true, because the lien waiver itself is a contract and they had an obligation to pay you. So, right in your main contract, whether it's a purchase order or whatever it is, they have an obligation. You have an obligation to perform and deliver labor and or materials, and you have and they have an obligation to pay you. So the payment that they gave you, because they'll say, we gave you the amount of money that's in this lien waiver. Well, okay, but they already had that obligation because it was in the contract. So there's no new consideration for this contract. The only place it falls flat, which means that you can try to overpower it and judges can, the best judges can see the difference. But remember reliance. It's the same thing here. When you were bidding, the contractor relied on your bid to give their bid to the owner. Here, the owner has relied on your lien waiver to pay the contractor to pay you. So the one that skipped the beat, unless they have actual knowledge, the one that's at the head, the owner, if they pay without actual knowledge that your lien waiver is wrong, you don't have lien rights. I actually fought that one time. Was a job in downtown Cleveland at the Union Club. And the contractor was going out of business. This was his last job. He had been, the last two jobs, this one and the one before, his electrical contractor had gone out of business, left him holding the bag for about $600,000. And he was really just going to walk away, pay himself, and be done and close the business. Not a good thing. So I had 6 different clients on that job that all had given lien waivers because it was with this guy, Chuck, and this wasn't Chuck, this was Bill. Bill always paid. He paid late, but he always paid. So people just gave him lien waivers. He wasn't paying this time. And when I found that out, I sent the architect was the owner's designee. I sent over a notice to the owner's designee not to rely on the lien waivers because they were incorrect. We hadn't been paid. I called the architect and said, look at your email, stop any payments on this project. And he laughed. He said, Russell, I've got an attorney telling me not or to ignore a legal document. And I said, that's absolutely right, because look at your email. I've just broken your reliance on it. And now if you pay, you've already been told verbally and in writing that these lien waivers are wrong. So you can no longer rely on the fact that the contractor has paid the subcontractor. And so now we're at least arm wrestling, and we can get the owner involved and try to get payment rather than fussing the wrong way. So how do you avoid these overbroad waivers? First, read and understand everything before you sign it. That includes your contract. That includes your lien waivers. That includes change orders. Lien waivers are everywhere. And that's one of the problems with them is, oh, you see, I've got a change order here. I needed extra time. I got extra time. I needed extra money. I got extra money. Okay, sign on the dotted line. Well, that works fine, except you stop reading partway through and you gave them an extra year of warranty and you waived all lien rights and you did all kinds of things. Be real careful. Understand it. If you don't, call your construction lawyer, have them look at it, call me. I told you before, I'm not going to charge you for it. I'll be happy to look at it. And for an overbroad waiver, you can modify it. You can cross stuff out. You can footnote it. You can do anything you want before you sign and deliver it, because it's the truth. Do the right thing and you're more likely to get paid. If you haven't been paid, this is the really one thing that's the most important. All the other things are important too, but this conditional lien waiver part, upon receipt of payment and when that check clears the bank on which it's drawn, that's the one that's going to save you so many times. And if you did it right from the beginning, you have 4 different lien waivers that you're going to use on this project all the way through: the conditional partial, the unconditional partial, the conditional final, and the unconditional final. Those are the right things to do. Get yourself set up so you're going along the right path. and you're getting paid what you're supposed to be paid, and you're keeping your lien rights so you can get paid in the future. Why do you want to keep your lien rights? Do you want to file a mechanics lien? No, you don't want to file a mechanics lien. Why not? Because you want to get paid. This will help you get paid and avoid having to file a mechanics lien, avoid having to do the rest. If you're still not getting paid, then you need to file a mechanics lien to A, tell them you're serious, and B, actually make a good business decision that this is the money that is mine, and I have the legal right to payment. You are a lender. When you're delivering materials or you're working on a job and you're not getting paid, for every day that you're working or delivering, you're lending money to the contractor and to the owner. If you went to, let's say you have $100 grand worth of material sitting there. Now, the average person isn't going to be able to go to the bank and say, well, I'd like to borrow $100,000 and no, I'm not going to give you a mortgage on my house. I'm just going to sign this signature loan. I'd prefer not to even do that. I'll just promise to pay you back. Well, there's a lot of that here. The lien is like the mortgage. The mortgage on a house, you borrow money to buy a house. You sign a note that says, I promise to pay you back. And you sign a mortgage that says, if I break my promise to pay you back, then take my house, sell it, pay yourself, and if there's anything left, give it to me. Same thing here. It's just the statute writes all those things between the lines and says, if you haven't been paid and you follow the rules, did your notice of furnishing, gave a good heed to all the lien waivers you signed, you get to the end and you still haven't been paid, depending upon what type of project you're working on. There's a different time period for filing each lien, and you're within your time period, you can file the lien and take your mortgage on that property. So if you're not paid, you can leverage getting paid by threatening to file a foreclosure action, or you can file a foreclosure action and get paid out of the money at the sheriff's sale. If there's any questions, I don't see any in the chat box. If you have any, send them up right now. If you have one and you want to get it out quickly, just say I've got a question, or chat me a question mark and I'll wait. Otherwise, I'll assume that I've answered everything. If you didn't hear everything, if you didn't understand anything, you just have more questions and you think about them tonight at 2 a.m., don't call me. I'll be in the office in the morning and I'll be happy to answer any questions. So give me a ring then, send me an email. I'll be happy to walk you through what you need on general kind of terms.
Well, thank you so much, Russell. I do want to add just a few pieces, which I'm sure everyone on this call knows. But first and foremost, a lot of the issues with your waivers and releases are because you signed in your contract at the very, 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 very beginning of a project, you signed a contract where you have to sign specific waivers and releases. So before you sign that contract, you definitely want to make sure with your attorney or with Russell that those waivers and releases are reviewed. And I think the second piece that's really important to know, that if you are a SunRay customer, all of those waivers in the specific language that Russell spoke about this morning are all in the SunRay application. So when you create your waivers from your notice of furnishings, you could do them all through the SunRay application for free. They could be stored there for you for further, if you need to see if you've done partials, et cetera, et cetera. But other than that, we'll wait just a quick second, see if there are any other questions. I don't believe there are. Well, Russell, thank you so much for a fabulous webinar on waivers and releases, and I wish everyone a sunny day.
Thank you, Ariella. It's always a pleasure.
Thank you.